Vimla, and today I would like to introduce a topic that has become increasingly significant in our discussions about personal autonomy and compassionate end of life care, the right to die with dignity. The concept of the right to die with dignity centers around the belief that individuals should have the freedom to make decisions about their own lives, including the choice to end their suffering when faced with a terminal illness or unbearable pain. It acknowledges that every person should have the autonomy to shape their own destiny, even in the face of the most challenging circumstances. At its core, the right to die with dignity advocates for passionate and respectful end of life options. It acknowledges that medical advancements have allowed us to extend life, but sometimes at the cost of prolonged suffering and loss of quality of life. By recognizing this right, we strive to provide individuals with the opportunity to die peacefully, surrounded by the loved ones, and in control of their own fate. It is important to note that the right to die with dignity does not advocate for the termination of life without careful consideration and necessary safeguards. Rather, it promotes a compassionate and regulated approach that ensures the protection of vulnerable individuals and provides a legal framework for making informed decisions about one's own life and death. Article 21 of the Indian Constitution states that no person shall be deprived of his life or personal liberty except in accordance with the procedure established by the law. So we can say that Article 21 protects two rights, the right to life and the right to personal freedom. The Government of Indian Act 1935 created Article 21 of the Indian Constitution. It declares that no one may be deprived of their life or personal freedom before doing so in the line with the legal process. One of the fundamental privileges to which all Indians are granted is listed in Article 21 of Part 3 of the Indian Constitution. Article 21 of Indian Constitution, a beacon of protection for citizen, is at the heart of the right to die with dignity in India. Article 21 guarantees that no one shall be deprived of their life or personal liberty except in accordance with the legal procedure. The right to life and the right to personal liberty are both protected by this constitutional article. From a historical standpoint of view, Article 21 has seen significant extensions, most notably in the landmark case of Menka Gandhi versus Union of India, which happened in 1978. Menka Gandhi's lawsuit was a crucial moment in understanding of personal liberty as defined in Article 21. The Supreme Court emphasized that the right to life includes more than just one physical survival. It also includes the right to live with dignity. This historical decision united the provisions of Article 19, 14, and 21, producing an indivisible entity that requires conformity to its validity of conditions. As a result, Article 21 has expanded to embrace a wide range of rights such as access to clean water, access to clean air, noise free settings, excellent education, prompt and fair trials, livelihood, legal aid, food, a clean environment, and healthcare. But why? I can understand that you must be very confused that why anyone would want to end his or her life so easily. But we need to understand that the decision to use euthanasia or medical assistance in dying is a complex and deeply personal one. People may consider euthanasia for a variety of reasons, including the following. First is terminal illness. Individuals with incurable and terminal conditions that cause extreme pain, suffering, or loss of dignity may choose euthanasia as a way to end their lives on their own terms. They may prefer a peaceful and controlled death over a prolonged period of suffering. The second is unbearable suffering. Some people may experience chronic pain or suffering that cannot be effectively elevated through available medical treatments. For them, euthanasia may seem as a compassionate choice to end their pain and avoid prolonged agony. Next is loss of autonomy. Many individuals highly value their independence and autonomy. However, certain medical conditions such as advanced stages of neurodegenerative diseases or severe disabilities can result in the loss of bodily and cognitive functions. Euthanasia can be seen as a way to maintain control over their own life and avoid becoming completely dependent on others. And next is quality of life. Some individuals prioritize their quality of life over its duration. They may feel that the condition has significantly diminished their ability to engage in activities they once enjoyed or maintained peaceful, meaningful relationships. For them, euthanasia can provide a dignified exit from a life that they no longer find fulfilling. So, before we move further, let's understand the historical perspective of the right to die with dignity. First, let's talk about the Menka Gandhi versus Union of Indian case. As we have already discussed about the famous Menka Gandhi versus Union of India case from 1978, let us now understand how important it was in the case of right to die with dignity. It redefined the meaning of phrase personal liberty as it was used in Article 21 of the Indian Constitution and greatly broadened its application. In this case, the court stressed that the right to life included the right to live in dignity as well as the right to physical survival. The most important component of the judgment was how the rules of Article 19, 14, and 21 interacted with one another. These clauses were combined by the Supreme Court into a single cohesive unit. Now, in order for a technique to be regarded genuine, it must meet each and every need stated in these articles. In addition to the greatly extending the scope of personal liberty, this ruling upheld the fundamental and constitutional right to life. Now, let's talk about Maruti Shripati Dubai versus the state of Maharashtra. A 1987 case before the Bombay High Court. The petitioner was detained after making an attempt at suicide and violation of Section 309 of the Indian Penal Code 1860 was filed against him. Later, he was freed on bond. The validity of Section 309 IPC was contested in this particular case, and it was questioned whether the sentence was cruel, severe, irrational, or even pointless. According to the Bombay High Court, the purpose of introducing Section 309 into the IPC was to prevent any prospective suicide, but that did not happen, and punishing individuals who are suicidal is a ridiculous method to do so. Instead, individuals require psychiatric treatment and mental health support to recover from his illness. As a result, the rule became unbreakable. The Section 309 clause was deemed to be ultra vires. The petitioner's ongoing prosecution was ruled to be invalid. All prosecutions initiated in accordance with Section 309 and ongoing in any of the state's court have been ruled invalid as a result of the court's decision to invalidate the section. Supreme Court maintained Maruti Shripati Dubal versus State of Maharashtra decision in Rathinam versus Union of Indian case, which was a separate case that was held in 1994. The Supreme Court decision bench ruled that Article 21 right to life also includes the right to die. So now you know that why this case was an important one. Now, let's discuss about the most important case in the whole presentation. the case of Aruna Shanbag. The Supreme Court ruled that individuals have the right to die with dignity, allowing passive euthanasia with guidelines. This decision was prompted by Aruna Shanbag. Aruna Shanbag was a nurse at King Edward Memorial Hospital in Mumbai. She was assaulted in 1973 by a ward boy named Sohanlal Valmiki, leaving her in a vegetative state for 42 years. Aruna survived on mashed food and was unable to move, speak, or perform basic functions. In 2011, the Supreme Court recognized passive euthanasia in her case, allowing the withdrawal of life sustaining treatments from the patients, unable to make informed decisions. However, opposition arose from the hospital staff and Bombay Municipal Corporation who opposed euthanasia for Aruna. The Supreme Court constituted a medical board to assess Aruna's health, which concluded that she was not brain dead and showed some response to stimuli. The nurses at the hospital had been caring her for years and were against euthanasia. Ultimately, on May 18, 2015, Aruna Shanbag passed away at the age of 66 due to severe pneumonia while on ventilator support in the hospital's acute care unit. So, now let us understand what euthanasia is. Euthanasia refers to the act of intentionally ending a person's life to relieve the suffering, usually due to a terminal illness or unbearable pain. There are two methods of euthanasia. First is active euthanasia. Active euthanasia is when a doctor intentionally ends the life of a patient who is suffering from incurable or terminal illness by giving them a fatal medicine. Remember, key here is giving them a fatal medication. Next is passive euthanasia. The act of withholding or discontinuing life sustaining care is referred to as passive euthanasia. And there are two types of consent for euthanasia. First is voluntary euthanasia. Voluntary euthanasia is when a person who is killed has requested to be killed. So, in voluntary euthanasia, the person has to give their consent to be killed. And the second one is non voluntary euthanasia. It is when a person who is killed makes no request and gives no consent, as the person is unable to communicate his wishes being in a vegetative state. So, we need to understand that there are two methods of euthanasia. First one is active euthanasia, second one is passive euthanasia. And there are two types of consent for euthanasia. First is voluntary euthanasia and second one is non-voluntary euthanasia. But euthanasia is never an easy process. Physician participation in physician assisted suicide, also known as PAS, and euthanasia can have a significant emotional and psychological toll on doctors, who may be deeply affected and astonished by the speed of patients' death and helplessness and also loneliness. Some patients have even threatened and intimidated the doctors into assisting them, indicating that countertransference in the doctor patient interaction can influence physicians' involvement in these practices. Whereas, in case of the family, a study found that the bereaved family and friends of cancer patients who died through euthanasia experienced a better coping methods and fewer grief symptoms and reduced post traumatic stress reactions compared to those whose loved ones died naturally. I am not advocating for euthanasia, but it is important to note that providing equal care and open communication for all terminally ill patients, regardless of the chosen end of life approach, is very, very crucial. Now let's talk about the legal position in other countries. In Netherlands, Euthanasia and assisted suicide are legal under the Termination of Life on Request and Assisted Suicide Act. This law, enacted in 2002, allows the physicians to perform euthanasia or assist in suicide if specific criteria are met. The key requirements include the patient's voluntary and well considered request, unbearable suffering with no prospect of improvement, consultation, and with at least one other physician, and adherence to specific procedural guidance. The cases are reviewed by the regional review committees to ensure the compliance with the law. In Belgium, euthanasia has been legalized through the Belgian Act on Euthanasia, similar to the Netherlands. This law established strict conditions for euthanasia and assisted suicide. It requires the patient to be in a hopeless medical situation, experiencing unbearable physical or psychological suffering, and to make a voluntary, well considered, and repeated request for euthanasia. The patient's request must be evaluated by two physicians, and a consultation with a psychiatrist is required in cases involving psychological suffering. In United States, euthanasia and assisted suicide laws vary at state level. As of my knowledge, a few states have enacted legislation allowing for physician assisted suicide. Oregon was the first state to legalize physician assisted suicide in 1997 through the Oregon Death with Dignity Act. Other states have since enacted similar laws, including Washington, California, Colorado, Hawaii, Maine, New Jersey, Vermont, and Washington, D.C. These laws typically have stringent requirements such as terminal diagnosis with a limited life expectancy, mental capacity to make an informed decision, and multiple requests to ensure voluntariness. In England, euthanasia and assisted suicide remain illegal under Suicide Act 1961. However, passive euthanasia, such as withdrawal or withholding of treatment, is legally permitted under certain circumstances. First is the Mental Capacity Act 2005. It established a legal framework for decision making on behalf of individuals who lack the capacity to make decisions for themselves. It allows the withholding or withdrawal of life sustaining treatment if it is deemed to be in the patient's best interest and in accordance with the proper medical care standards. In India, active euthanasia is punishable under Section 304 of the IPC and falls under culpable homicide, but it does not amount to murder. Recalling the Arunas case, in 2011, an activist petitioned the Supreme Court of India on Aruna's behalf, claiming that her right to live in dignity is being violated by her continued existence. Although the court did not let Ms. Shanbag's medical care to be discontinued, it extensively reviewed and approved passive euthanasia. Further, it was decided that the High Courts, acting as the parents parshe principle or the parents of the nation, by the court can intervene and act as a guardian of terminally ill patient, are the last arbiters of what is best for the patient. The Supreme Court issued several guidelines on the subject and decided that the High Court should make its ruling after hearing from all the benches and committees appointed in accordance with the guidelines. The High Court was instructed to hold off on making its rule until the Parliament passed laws on the subject, and the Supreme Court ruled that the outlined procedure should be followed throughout the India. On March 9, 2018, the Supreme Court made a significant ruling in the case of Common Cause versus Union of India that legalized physician assisted suicide, also referred to as passive euthanasia. The court found that an adult human who has the mental capacity to make an informed decision has the right to die with dignity, as it was earlier held by its constitutional bench in Giacor case. To conclude, it should be kept in mind that a dying man has the right to pass away with dignity when his life is on the verge of ending. Also, speeding death in order to shorten the suffering time for a person who is terminally sick or in persistent vegetative state where there is no chance of recovery is in accordance with the right to a dignified life. The Supreme Court's reconsideration of the issue is a huge step. It's highly likely that even the recently updated rules may eventually need to be changed, but making things simpler for consent providers without raising the possibility of abuse of this major decision by the apex court must be the guiding principle. Thank you.